I can tell that you're talking, but I can't hear you. Mr. Wittershine, do you want to try your mic again?
Hi there, confirming that you can see and hear me.
Yes, I can.
Thank you so much.
Test, test.
Yes, I can hear you, Mr. Dunman.
Thank you.
Good afternoon. We're back on the record in proceeding 25A-0075E Public Service Company's application to join Markets Plus. Any preliminary matters? I guess, Mr. Denman?
Yes, I have one or two, Your Honor. Yesterday, my witnesses offered to do a little research and respond to a couple of questions that Commissioner Gilman had asked. I am prepared to announce the answers to those questions in the record, if that's acceptable to the commission. If you would prefer that I recall witnesses, we could do it that way as well.
Ms. Rosati, are you there? Do you think it's okay for counsel to just provide the answers to those questions, sort of akin to a statement of position?
I think it would be appropriate to check with the other parties to see if they have any issues with that.
Any concerns among counsel for the other parties? Would you prefer recall the witnesses, or are you okay with Mr. Denman? Thoughts, comments, questions, concerns?
Staff has no objection to Mr. Denman providing the information.
All right. Hearing no other concerns, Mr. Denman?
Thank you. Thank you, Ms. Rosati, as well. Commissioner Gilman asked Mr. Bacher on what load forecast was used in line 17 of attachment MRG-4 revised, and that's in hearing exhibit 102. Mr. Bacher has advised me that both line 3, the revenue from retail, and line 17, electric retail sales in gigawatt hours, were taken from an attachment in proceeding 24A-0442E, attachment JWI-5, and they represent the base case forecast.
Thank you. I assume, Commissioner Gilman, that addresses your question.
Yes, thanks, Mr. Denman.
Certainly. And secondly, Commissioner Gilman, you asked Mr. Turner regarding the termination or exit provisions in the Market Plus Phase 2 funders exhibit. And that's hearing exhibit attachment, hearing exhibit 101, attachment JCT-3, the Markets Plus Phase 2 funding agreement. There are two places you might want to look. On page 9 of that exhibit, section 7D Romanet 2 discusses termination by a Phase 2 funder prior to Markets Plus going live. And then once a withdrawal notice is delivered to SPP, the parties have 20 days of good faith negotiations to determine if concerns leading to the withdrawal are capable of resolution. And if not, the termination then becomes effective and the withdrawing party's Phase 2 funding is paid in full to SPP. And there are other provisions that deal with withdrawals after the go live date of Market Plus. And the same type of provisions apply, and that can be found in section 7E Romanet 2 on page 12 of that exhibit. Were you able to jot down those references, ma'am?
Yes, thank you.
Okay, you're very welcome. And that completes responding to those information requests by Commissioner Gilman.
Thank you, Mr. Denman. Any other preliminary matters before we jump to Mr. Turner? Ms. King.
Thank you. I'd like to renew my motion to enter what has been marked as hearing exhibit 902 into the record, the foundation for which was laid during my cross-examination of Mr. Bachman yesterday.
Any objections, Mr. Denman?
I can tell Your Honor that I had my folks, as well as I took a look, go through the math and verify the math is correct. And we have no objection to admission of hearing exhibit 902.
So admitted. Mr. Burriso.
Yes, thank you. In reviewing the cross-examination matrix for today, we'd realized that Ms. Kelly was listed first for WRA. Consistent with typical practice, we'd assumed that Ms. Welter would take the stand first since she was assigned the first hearing exhibit number. And so if it's okay with yourself and the commissioners, we would request that that order of witnesses be flipped. I'd advise counsel for public service of this, but admittedly, it was just a few minutes before the hearing resumed earlier today.
Mr. Denman or any of the other parties concerns with flipping the witnesses? I'm okay with that. And Commissioner Gilman and Plant, any concerns? Mr. Denman?
And Your Honor, I responded to Mr. Barroso and told him no worries about that. That's fine.
All right. We'll take Ms. Welter first. Thank you, Mr. Barroso. Any other preliminary matters?
I have none.
All right. Mr. Turner, are you out there?
I am. Good afternoon.
Oh, there you are. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No,
If that changes, will you let us know?
I will.
Back to you, Ms. King.
Thank you very much. Mr. Turner, can you please state your full name for the record, please?
Brian Turner,
And what is your employer and your position?
Advanced Energy United, and I am a director of Western Regulatory Policy.
Thank you. And did you prepare or cause to be prepared hearing exhibit 900, the answer or testimony of Brian Turner on behalf of Advanced Energy United and its associated attachments?
Yes.
And did you also prepare or cause to be prepared revision 1 to hearing exhibit 900?
Yes.
And if I asked you today the same questions presented in that revised answer testimony, would your answers be the same?
Yes, except for two questions. When I was preparing for today's hearing, I noticed two minor errors in my answer testimony that I would like to correct now, if I may.
Can you please explain the first error that you would like to correct in your testimony?
On page 38 of my answer testimony, I referenced the year 2040, which I note is 15 years from now. I should have instead referred to 2039, which is 14 years from now.
Thank you. And is that also reflected in the summary section of your answer testimony?
Yes, thank you. It is. On page 6, I also referenced 2040, which should also be updated to 2039.
Thank you. And can you please explain that second error that you would like to fix?
On page 44 of my answer testimony, I refer to the SPP Executive Committee. I should have instead referred to the SPP Members Committee.
Thank you. And Mr. Turner, did you cause to be prepared today a document pre-marked as hearing exhibit 900, revision 2, reflecting these changes and no other changes?
Yes.
And if I asked you today the same questions as presented in that proposed revision 2, would your answers be the same?
Yes.
Chairman Blank, a proposed copy of revision 2 to hearing exhibit 902 was circulated to council earlier today after we realized these errors. I've not heard any objections from council and would like to please move to enter hearing exhibit 900 revision 2 into the record.
Any objections?
No objection.
Hearing none, so moved.
Thank you. And Mr. Turner, did you prepare or cause to be prepared hearing exhibit 901, the cross answer testimony of Brian Turner on behalf of Advanced Energy United?
Yes, I did.
And if I asked you the same questions in the cross-answer testimony today, would your answers be the same? Thank you, Chairman. Mr. Turner is available for cross.
Mr. Denman, I have 60 minutes for you.
Thank you. Public Service Company has determined that we effectively refuted the challenges by Mr. Turner in our rebuttal testimony, so I have no questions for cross-examination.
Commissioner Gilman, questions for Mr. Turner?
I don't have any questions. Thanks.
Commissioner Plant, questions for Mr. Turner?
Thank you. And hello, Mr. Turner. Good afternoon.
Hello, good afternoon.
I guess it's just afternoon where you are. I just have one quick question. In reading through your testimony, it seems that there's two concerns, broadly speaking, a lot of, specific concerns, but broadly speaking, there's two concerns. One is that there was an adequate consideration of EDAM as an alternative to Markets Plus and as a day-ahead market. And the other seems to be sort of a consideration that to go into Markets Plus may be to sort of prevent or avoid the issue of entering into a regional, an RTO basically, or an ISO at some future point. And I'm wondering if those are concerns that you have, and if so, if you could kind of explain some of the concerns behind it. Are there specific advantages to an RTO over the Markets Plus? Are there specific components of EDAM that you're concerned weren't considered here, or that would be more beneficial than a Markets Plus scenario?
Sure. Thank you. So I'll take those each in turn. I heard two questions there. First, regarding EDAM, I want to be clear that I think the decision before the Commission now is whether Public Services application to join Markets Plus is in the public interest. And so my references to EDAM in that context were twofold. One is whether the analysis completed by Public Service regarding entry into Markets Plus was adequate. And there are the structure of EDAM and the benefits available there are relative to what the analysis for entering Markets Plus is. So it was not meant to be directly comparative, that EDAM would be the better choice at this time, merely that the analysis that Public Service completed, which is several years old, was, as many witnesses have demonstrated, very cursory and not really applicable to the Markets Plus footprint and proposition that we have before us. So that was one context. The other being that the availability of other market options lowers the risk to the Commission, to the company, to Colorado ratepayers of taking some more time now to see how this very dynamic Western market situation develops. And specifically, one of the developments that I reference is the Pathways Initiative to create truly independent governance over what would be the EDAM market, but adopted by this new Western regional organization. So that it was meant to reference the lower risk of waiting now, denying this application without prejudice, so that we can see how those developments occur. So that was an answer to your first question. On the second question regarding Markets Plus versus an RTO, yes, I think it's well understood that an RTO does offer substantially more benefits. The balancing authority consolidation, de-pancaking of transmission rates, truly optimized dispatch and unit commitment across a wide footprint are just a step change above the benefits available to just a day-ahead market or day-ahead in real-time market. And that should be one of the considerations that the commission makes now. And I am concerned that the Markets Plus application prejudices or affects that RTO decision in a couple of ways. One is that, as the company has said, they view the Markets Plus application as demonstrating their good faith efforts or their diligent efforts. I'm sorry if I'm not getting the right language from SB 72, but the part of the requirements of SB 72, that this application accomplishes some of the requirements there. And at the same time, that this application actually puts a roadblock to RTO entry. The company has said now several times that they would view an RTO entry application as needing to overcome the sunk costs of Markets Plus entry. So were this application to be approved, we would in effect be putting an additional roadblock to near-term entry into an RTO into place without having examined the implications of that, implications of the benefits to Colorado or compliance with SB 72. So those are the two things that I'd say in response to Markets Plus versus RTO. Does that answer your question?
It does. Thank you very much. And you mentioned the pathways sort of time frame and waiting until we had more information about it, what that was going to be structured like. What do you have any sense of what the time frame is there? I know that there's some still unresolved issues at the I think the California legislative level as it relates to governance, and then there's sort of all the other issues surrounding pathways. I think one of the things we've talked about through the course of this hearing is the 18 months prior to the sort of deadline for implementing a regional market. And is it your sense that Pathways is on course to sort of resolve all those issues prior to that 18-month timeframe, or where are they in that whole process?
Yes. So the Pathways proposal to create this independent regional organization is complete. That was completed in November of last year. Now we have moved to two tracks. One is implementation planning by the Pathways Committee. And just for clarity purposes, I sit on the Pathways Launch Committee, which is separate from CAISO. It is a group of Western stakeholders from many states, many sectors, developing this proposal. And we are currently planning the implementation, including setting up the 501c3 organization, seating an initial board, raising a budget, et cetera, all the implementation details planned for after the first track, which is California legislative change. That California legislative change would do two things: allow for the CAISO to operate the markets according to the governance, the independent governance of the regional organization. And the second thing is allow for California utilities to participate in this separate regional organization. And that legislation is on track. It's passed two committees in the Senate now unanimously, is headed next to the Senate floor in California. And the date we're using for timeline is, I think it's October 12th. Roughly is the last date that the governor has to sign bills from this session. So we anticipate that by that date, we will know the fate of the Pathways Initiative, which is not far off.
Great. Well, thank you for that that clarification, and I appreciate it. I have no further questions, Mr. Chairman.
Thank you, Commissioner Plant. Just a few questions for you. From Mr. Taylor's oral testimony, in my own general sense, it seems like one of Colorado's two balancing authorities, the one run by WAPA, is committed to SPP RTO West because it and the other market participants have load and generation in both SPP RTO East and West. Is that generally consistent with your understanding, or would you say it differently?
I don't have an inconsistent understanding.
Okay. And is it fair to say that this commission doesn't have any meaningful jurisdiction over WAPA and over a limited authority, certainly not rate setting authority over Tri-State? Is that right?
That's my understanding, yes.
Yeah. All right. Well, Given these realities, is it likely that Colorado might be better off having one operator running both the RTO and the day-ahead market with our two balancing authorities as compared to having a CAISO SPP seam running down the middle of Colorado?
I think given the situation that you've outlined, there is likely to be a seam regardless. And I think that there is an assumption that a single operator will assist in mitigating those seams, but to be honest, I am not aware of the evidence to support that assumption.
All right. But it seems like at least it's the same entity across both. So there's control over the modeling, there's control over the tariff filings. It just seems like logically it'd be easier, but I hear you. I don't think anybody's modeled it, but the common sense understanding would be it might be easier for all those reasons. Do you disagree with that?
Well, I understand I understand the contention. I will say I do believe that they are separate models, and for much of the tariff filing, I believe it'd be two decision-making bodies anyway. Of course, the SPP Board of Directors retains the Section 205 filing rights in both markets. However, the decision-making for non-material or most decisions for Markets Plus is the Markets Plus independent panel, separate from the SPP Board of Directors and Members Committee.
Fair enough. I appreciate that. I just have a couple questions on the RTO versus the day-ahead market, particularly as it applies to SPP RTO West. And just by background, it sounds like AEU is involved in most RTOs nationally, and that your personal role is across the entire West. Is that fair?
Yes, Advanced Energy United does have a team that is involved in all the RTO and ISOs except for the California ISO. I am not a member of that team, though I do speak with them frequently.
Okay. And I just want to talk about one issue involving transmission cost allocation, particularly in SPP RTO West. As I understand it, the SPP tariff has a highway byway approach to transmission cost allocation, where transmission costs are allocated to individual members based essentially on their peak demand. Is that consistent with your understanding?
I'm afraid I do not know SPP at that level of detail.
Okay. Just a couple more questions. Well, actually, let me just ask you one more question on that. If it was that way, is it fair to say, based on peak demand and Mr. Taylor's oral testimony, that roughly 70% of the transmission costs would be allocated to public service? And maybe it's probably, well, I don't know.
I'm afraid I don't know, and I don't know what the RTO expansion plans, whether there's any difference there.
Fair enough. On page 17 to 18 of your answer testimony, and we don't have to pull it up, you express a concern that the Trump administration may interfere with state efforts to address climate change. All other things equal, do you think the risk of federal interference might be greater for CAISO as opposed to SPP?
No. I don't believe that there's reason to suspect that that would be the case. As we've seen with the orders so far, the ones that Ms. Keene brought up yesterday, regarding the orders on capacity, the Department of Energy examining capacity in different markets, for instance, that applies nationwide. And the first application that we saw was in MISO, where a coal plant was ordered to stay online. And if I may, just I do believe that this is a real issue across markets, and that those states with climate goals should be preparing, and that there are mitigation plans that could be put into place. So I don't mean to propose that this is something that should argue against participation in regional energy markets, but that some more time to prepare those strategic mitigation plans about what to do if federal policy were to conflict with state policy would be very helpful to states with climate goals.
Fair enough. And regarding the joint GHG tracking and reporting letter developed by Tri-State and Public Service Company, I think you mentioned it in your testimony. Given that it seems to be separate from the SPP tariff filing and under state jurisdiction, do you see any ways that the administration could somehow interfere with that? And if so, how?
I have not thought of a specific way that that letter would be under risk. I could speculate about what the various ways the federal government could try to interfere with policy. But I don't know if that's what you're asking for. I don't know if that's where we want to go right now.
All right, that's all I had. Ms. Keene, redirect.
There we are. Yes, thank you. Just a couple of things. A moment ago, you referred to a couple of orders coming out of the federal government. Do you recall that?
Yes.
Just for purposes of cleaning up the record, was the executive order that you referred to the same as the April 8th executive order issued by President Trump called Strengthening the Reliability and Security of the United States Electric Grid?
It is.
And is the Department of Energy order that you issued the same as the May 23rd order from the U.S. Secretary of Energy, Chris Wright, entitled Energy Secretary entitled Emergency Order to Secure Grid Reliability Ahead of Summer Months?
It is.
Thank you. And then just one other question. When you were speaking with Commissioner Plant regarding the 18-month timeline relating to SB 72, do you recall that discussion?
Mm-hmm. Yes.
And is it your understanding that if the pathways efforts resulted in an RTO that Public Service or other Colorado utilities were interested in joining, but it wasn't quite ready for that 18-month time period ahead of 2030, that the statute allows them to request a delay from the commission if needed?
That is my understanding.
Thank you, and nothing further.
Thank you, Mr. Turner. You may be excused.
Thank you.
I guess Mr. Barroso, Ms. Welter. Ms. Welter, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Can you put your hand down? Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
Back to you, Mr. Barroso.
Thank you, and good afternoon, Ms. Welter.
Good afternoon.
Could you please state and spell your name for the record?
Yes, my name is Sydney Welter, and that is spelled SYDNEYWELTER.
Thank you. And Ms. Welter, would you please identify by whom you are employed and in what capacity?
Yes, I'm employed by Western Resource Advocates, WRA, as the Regional Markets Policy Advisor.
And did you cause to be filed answer testimony and attachments in this proceeding, which have been pre-marked as hearing exhibit 1200 and attachments?
Yes.
Thank you. With that, Mr. Chair, Ms. Welter is available for cross-examination.
Mr. Denman.
There, thank you, Your Honor. Ms. Welter, my name is Steve Denman. I was Public Service Company's counsel in the Weiss case, so we may have met online during our settlement negotiations.
Yes.
And I know you're new to testifying in front of the commission, but would you say that the role of the commission, in this case or any other, is to decide whether an application and the evidence comply with its rule requirements?
Yes.
I'm gonna have to object. We'll see where this line of questioning goes, but it sounds like Mr. Denman is asking the witness to speak to the commission's authority and provide a legal conclusion.
No, I'm not. She's not testifying as an expert witness, so I just wanted to make sure she understood the role. I'll move on, Your Honor.
Yeah, overruled. Keep going.
On page, let me take my clip off so I can find your page. Page 4 of your testimony, you say that you testified before the commission in proceeding 25A-0075E. That's the Western Energy Imbalance Services, or WEIS, W-E-I-S application, isn't it?
Yes.
Now, isn't it actually true that you did not testify in a hearing that was held on the settlement in that case, but you only filed testimony in support of the settlement?
That's correct.
And in that docket, WRA did not file answer testimony, did it?
I need to confirm that, but
it's okay if you say,
correct.
if you don't know, it's okay to say you don't know.
I don't know, but I believe that's correct.
Okay. On page 5 of your testimony, you and I'm looking at line 22 if you want to refer to it, but
Yes.
Tracy, I don't know that you need to call it out. You testify that the Markets Plus GHG tracking and accounting system does not ensure compliance, and then you go on to talk about some what you call, quote, parking lot, close quote, items from the GHG task force. Are you familiar with that testimony?
Yes, I am.
Are you a member of the GHG task force of Markets Plus?
Yes, I am.
And are you participating in any similar tracking and reporting program with the California ISO?
There is in the California ISO, a greenhouse gas coordination working group with open meetings that I have attended.
So you're only attending and observing those meetings?
To be clear, the structure of those two, the Markets Plus Greenhouse Gas Task Force and the CAISO GHG Coordination Work Group, those structures are different. The Markets Plus GHG Task Force is the one that has voting member seats.
Okay, thank you. Do you understand that we're about 2 years away from the start of Markets Plus?
Yes, my understanding is that Markets Plus is slated to go live October 2027.
Okay, thank you. Is it surprising to you that tracking and reporting protocols are not yet complete 2 years in advance of the start?
I think these are new markets for the West, and it takes time to continue to develop these protocols, and things need to be evaluated where they are at in development. But understand these are two new markets attempting to enter the West for the first time.
And did you tell me a moment ago that you're a voting member of the GHG task force?
That is correct.
I thought so. Have you been present in the GHG accounting and reporting protocol development by that task force?
Yes.
And when the Okay, and in your role as a voting member of the GHG task force, have you been present when, oh, pardon me, I think I skipped something. Strike that. When the latest version of the GHG accounting and reporting protocols were voted on in the meeting, and I'll suggest that was September 24th of 2024, were you present for the vote?
I'd need to confirm, but I believe yes.
And how did you vote? Do you remember that?
I believe voted yes to approve.
Okay, and so when these protocols were presented to the MPEC in April of 2025, was the WRA having a voting member present?
Yes, I believe we did.
And can you tell me, are you the representative of WRA on the MPEC?
The appointed voting representative on the Markets Plus Executive Committee from WRA is Vijay Satyal.
Can you spell that name for the court reporter, please?
Yes, that name is Vijay, Vijay, and last name is Satyal, Satyal.
Thank you. Let's go to page 11 of your testimony, please.
Yes.
Hearing exhibit 1200. On line 6 and 7,
Yes.
you say, can you read those two lines through the end of the sentence to yourself, please?
Yes. I have.
Okay. And there you're discussing an April 2025 report by the Brattle, BRATTLE group. Is that correct?
That is correct.
And is that your attachment SW-2?
That is correct.
Okay, and then later on, you give some recommendations between lines 10 and 12. And if you need to read those to refresh your memory, go ahead.
All right. I have read
Okay,
those.
thank you. Do you plan to introduce these recommendations you've stated here to the Markets Plus GHG Task Force?
Yes.
Thank you. Your Honor, let me check my notes. That concludes my cross-examination. Thank you.
Thank you. Commissioner Goman, questions for Ms. Welter?
No questions, thanks.
Commissioner Plant?
I have no questions, thanks.
Ms. Welter, can we pull up your answer testimony at page 9, line 3? And I think here you say that public service has not demonstrated that Market Plus has in place protocols that will implement a GHG tracking and accounting system, enabling the fair and timely tracking, reporting, and accounting of GHG emissions sufficient to ensure compliance with Colorado's emission reduction requirements. Do you see that?
Yes, I do.
All right, can we go down to page 11, line 10? I think we were just talking about this with Mr. Denman. You make a series of recommendations that presumably, if were put in place in protocols, would ensure compliance with Colorado's GHG reduction requirements. Is that fair?
What I would say is that these would certainly support compliance, but I'm not suggesting that this addresses the full scope of issues that continue to need to be developed in Markets Plus to ensure that this meets those regulatory requirements for Colorado. That includes some of those items still in that Markets Plus parking lot. But yeah, to reiterate, I think these recommendations overall would support continued refinement of the greenhouse gas accounting and tracking mechanism in Markets Plus.
All right, let's go through them. The fourth one on lines 16 to 17 is enhancing representation of transmission system limitations to limit the maximum quantity of market attributed megawatt supply. Do you see that?
Yes.
All right, can we pull up hearing exhibit 101 JCT-4, and we can keep Ms. Welter's answer testimony handy, but can we pull up hearing exhibit 101 attachment JCT-4? And let me represent to you, this is the Tri-State Public Service Company letter. And can we go to bullet 1 entitled GHG region? And can you read that to yourself?
I've read that.
All right. And with this approach, which identifies specific transmission constrained balancing areas that are directly interconnected to Colorado's Market Plus balancing authorities, would that fully implement your recommendation about transmission system limitations? If not, can you explain why not?
I think this could fulfill that recommendation. Of course, would take a look at our technical experts, the Brattle Group, on the full scope of their recommendation. But I do think this component here in this letter, which we have just read, is a key part of implementing that fourth recommendation from my testimony.
All right. Can we go back to your testimony and look at the first recommendation? I think it talks about the need to align qualification requirements for attributable non-emitted megawatts with exclusive clean energy claims and REC-based accounting. Do you see that?
Yes, I do.
All right, can we go back to the letter, bullet number 2? Again, does this approach mapping responsibility for GHG emissions from thermal resources back to the entity claiming a capacity credit fully implement your recommendation? If not, can you explain why not?
Yes, I'm just reading this here.
Please take your time.
I think this resource mapping approach, again, is a key part of ensuring this accounting system will work for Colorado. I don't believe this addresses the full scope of concerns around potential double counting and clean energy claims in the market.
Can you help me understand why not?
Yes, well, I think this resource mapping approach will capture, it provides a lot of that confirmation necessary. However, there are still, I know in Markets Plus development, still questions to be answered about how this will work in market transactions when different states have different approaches to clean energy claims. So I think this is important for Colorado here, what's on the page here for resource mapping, but may not encompass the full scope of ensuring Colorado is getting what it needs from the broader market.
Okay. Let's go to recommendation number 2 in your testimony. It says that the market operator should apply the in-market calculated residual mix for any unspecified market purchases. You see that?
Yes, I do.
Can we go back to the letter, bullet number 3, entitled Excess Energy Allocation Methodology? I believe this requires the application of a residual market mix emissions factor to Market Plus purchases and sales using the Air Pollution Control Division workbook in the calculations of annual emissions. Again, does this approach fully implement your recommendation? If not, can you explain why not?
Yes, I'm just refreshing myself here. It's WRA's perspective that this economic order resource stack method, which we have supported in this Markets Plus development process, is a key step towards ensuring that recommendation is met for Colorado. We are concerned with how this will work for Colorado utilities in the market when methodologies are differing between different utilities. I think as described in testimony and attachments, there are multiple different methodologies that different market participants are selecting. However, with the options available from Markets Plus currently, do agree that this is the best approach for Colorado, this economic order resource stack.
And just to be clear, this applies both over Markets Plus and SPP RTO West, is that correct?
I would need to confirm that, but it is my understanding that this approach is also being adopted in the SPP RTO refinements for the Western expansion.
Okay. If we could go back to your testimony. In bullet 3 in your answer to testimony recommends expanding the use of in-market attribution of megawatts to apply to both GHG pricing and non-pricing states. And would the allocation process defined in the existing GHG protocols expand the use of in-market attribution of megawatts to apply to both GHG pricing and non-pricing states, and thus address your recommendation? If not, why not?
Yes, I think the current approach available in the Markets Plus design is expanding that attribution. We have other ongoing concerns around the handling of pricing and non-pricing states, but I know this is an issue that continues to be in development at Markets Plus. So I think things are getting there on this topic, but I'd see the full scope of recommendations in the Brattle report, and I think need to continue to refine some specifics around that attribution to ensure that non-pricing states, such as Colorado specifically in this instance, have a design available to support compliance with these Colorado policies.
Can we go back to the letter hearing exhibit? I think, yeah. Can we go down to bullet 4? And it sounds like bullet 4 puts in place provisions to ensure that state regulators, both air quality and economic, have access to the highly confidential hourly emissions and generation data to confirm that GHG tracking and reporting is done properly. Would you agree with that?
It is my understanding that yes, that lots of data will be made available to Markets Plus participants. I do not know off the top of my head the full extent of what all that data includes through the Metra portal, but understand that this data will be important to evaluating public service company and tri-states.
So I guess I share some of your concerns about
Sure.
the limitations of the SPP GHG protocols when looked at in isolation. But when combined with this public service company tri-state letter, which also covers SPP RTO West, it seems like this could be a workable framework for putting in place GHG tracking and reporting protocols to ensure compliance with Colorado's emission reduction requirements consistent with your recommendation. If not, what additions would you add to this letter to address any remaining concerns?
While I agree that this letter is an important step in ensuring that the Markets Plus greenhouse gas design framework supports compliance with Colorado rules, I am concerned with evaluating the market design in the tariff and business proposals as it currently stands, and its demonstrable ability to facilitate compliance with Colorado emission reduction regulations, which I think gets back to some of the points raised in my testimony around providing that modeling around emissions reductions. So again, to be short, I think this letter is one component of ensuring compliance, but it does not encompass everything that needs to be evaluated to ensure a public service company is meeting that requirement in the rule.
And did you and WRA have an opportunity to review and modify this letter prior to signature? And could you have added additions to this to address those concerns?
I do believe yes, I recall this letter being shared with us in advance of Public Service Company and Tri-State signing. I don't know to the extent to which any additions would have been from us would have been added to this, but yes, we did see this letter.
Okay. You can take it down. Just one last set of questions. Can we pull out what has been marked as hearing exhibit 1500? And let me represent to you that these are the objections and comments of NRDC and WRA filed in a prior M docket about verifying utility voluntary clean energy plans. Do you see that?
Yes.
All right, can we turn to page 6? And can you please read and scroll down a little? Can you just please read the first couple of paragraphs to yourself?
Yes. All right, I have read this.
Yeah, and basically, a distribution co-op in Colorado was able to claim that by assigning a wholesale market sales contract, seemingly perhaps with no economic impact, that it was no longer responsible for the GHG emissions from a cell phone coal plant. Would you agree with that, or would you say that differently?
I don't know that I can answer this question as I did not participate in this proceeding, though I see what is contained here.
Fair enough. Are you aware of anything under current regulation that would enable either this commission or the Air Pollution Control Division to address a problem like this?
Again, I'm not sure.
Okay. Last question. Going back to the Tri-State Public Service Company letter, is it fair to say that defining a transmission constrained region and by mapping the GHG emissions to the entity claiming the capacity credit, problems like this that exist under the status quo would go away under Markets Plus?
I think it could potentially be helpful in that scenario.
Okay. Thank you. Thank you, Ms. Walter. Mr. Brasso, redirect.
Yes, thank you, Mr. Chair. Just a few questions here. Ms. Walter, do you recall that Mr. Denman asked you a series of questions about the development of Markets Plus GHG protocols?
Yes.
I believe you discussed the development of those with Chair Blank as well. Is that right?
That's correct.
And you were also asked about your role on the Markets Plus GHG task force.
Yes.
Is there anything that you'd like to add or clarify regarding your and WRA's role on that task force?
Yes, I would just like to clarify that the decisions we make on whether to vote a certain way on certain proposals before the GHG task force, the reasoning behind those decisions vary. And there we are looking at a different question about the language in protocols compared to what we are looking at in this proceeding, which is this design sufficient to meet the public interest criteria around greenhouse gas reporting and tracking?
Thank you. And Mr. Denman also asked you about a September, and apologies, I don't have the exact date, but a September 2024 vote on those GHG protocols.
Yes.
Is there anything that you'd like to add regarding the nature of that vote?
Yes, again, similar to my response to your previous question, would just like to reiterate that when we are looking at language development around protocols before the task force, sometimes the way we vote varies, and while we are sometimes approve language that we see as sufficient for where things are at in Markets Plus development currently, still hold the position as described in detail in my testimony that the current greenhouse gas design does not meet the public interest criteria around GHG tracking and reporting.
Thank you. And last series of questions here. You at the end had a discussion with Chair Blank regarding attachment JCT4, the letter from Public Service and Tri-State. Do you remember that?
Yes, I do.
Could you expand on your understanding of whether that letter is a protocol developed by SPP Markets Plus?
Sure. Yeah. To my understanding, this letter was an agreement signed by Public Service Company and Tri-State outside of the existing approved protocols for Markets Plus.
Okay. Thank you, Ms. Welter. Those are all my questions. Thank you, Chair.
Thanks, Ms. Welter. You may be excused. Ms. Kelly, are you out there? Can you hold up your right hand? Do you swear to tell the truth, the whole truth? That's your left hand.
I know, but my audio wasn't on and I needed
Oh.
my hand. Excuse me.
Miss, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put down both hands.
Thank you.
Is anybody with you or communicating with you in any way?
My cat is next to me and she may become a problem, but she's calm at the moment, but that's it.
All right. If that changes or your cat becomes less calm, you'll let us know.
Absolutely. Thank you.
Mr. Burris.
Good afternoon, Ms. Kelly.
Good afternoon.
Could you please state and spell your name for the record?
Nancy Kelly, Nancy Kelly.
And would you please identify by whom you are employed and in what capacity?
I'm employed, excuse me, by Western Resource Advocates as a senior policy advisor.
Thank you.
Excuse me.
That's all right. And did you cause to be filed answer testimony in this proceeding, which has been pre-marked as hearing exhibit 1201?
I did.
Thank you. And that testimony has been stipulated for admission into the record. That Ms. Kelly is available for cross-examination.
Mr. Denman.
Thank you. And Ms. Kelly, I respect that you're a cat owner, as am I. Your Honor, Public Service Company has determined that we've sufficiently dealt with and refuted all the challenges Ms. Kelly talked about, so I have no questions for cross-examination.
Commissioner Gilman.
I have no question.
Commissioner Plant.
I have no questions.
I have a couple for you. On page 32, starting at line 15 of your answer testimony, you say that you would expect the production cost savings for public service from participation in either CAISO, EDAM versus Market Plus to be similar given the current configuration of utility choices and public services relative economic isolation. Did I read that right?
You did.
And I guess that seems right to me as I read through the modeling results and the answer and rebuttal testimony and listening to the cross of Mr. Bacher. I was struck by the relatively small size of both the benefits and the cost. To put this in context, and as Ms. King said yesterday, Public Service Company is separately proposing to the financial community to spend over $20 billion in capital in Colorado over the next 5 years. It's maybe 500 to 1,000 times greater than the cost at stake in this case. As such, I find myself trying to sort through the qualitative impacts of this decision as much as the modeling outcomes. Just any thoughts on how we struggle with the qualitative issues versus the quantitative ones?
Well, may I begin on the quantitative side, which is that the public interest criteria requires that the benefits exceed the costs to be determined in the public interest. And in this case, I do not see that you have that evidence before you. My testimony went into great detail with what is wrong with the production cost estimates, the lack of reliability improvement, and the lack of evidence of emission reductions. So just based on that third criteria, I would say you cannot find it in the public interest. And then Ms. Welter's testimony addressed the other two public interest criteria as laid out in Rule 3753A. With regard to the qualitative issues, it seems to me that more quantitative analysis is actually needed because you don't have it, because your Weiss market is gone. You do have a seam going through Colorado because unless public service joins the RTO expansion, you have a seam. And that's going to exist. And you had asked, I believe it was Brian, about the common sense thought that having the seam managed by the same operator would lead to a better outcome. And I don't think that that's clear at all at this point in time. There's a lot of things being developed and in process. And it seems to me that to deny at this time, but without prejudice, to request that public service come back and make their case for Markets Plus to demonstrate the economic benefits is reasonable. And at the same time, as I recommended in my testimony, to do a true comparative analysis with the other markets. And that would get to the point that you raised, Chairman, regarding transmission costs. In my recommendation, I suggested that a part of an overall comparative analysis would look at the need for transmission expansion and which other entities would provide the better partners for building out transmission. And coming back to that 2026 production cost estimate that came out of Alternative 2 App 4, which is a market footprint that is not tied to anything that we've looked at. It's just sort of drawn out of the air. taking that estimate and allowing it to be the basis for a decision is remarkable to me. I had another thought about that, which is why I went to it and then lost that thought. But anyway, with regards to the qualitative things to be examined, I think that those qualitative things do come down to quantitative things, to requiring solid analysis of production costs, estimates of emissions reductions, but significantly of transmission expansion and where that would be best suited. And also, while you're at it, this is not my area, I think that a true evaluation should also look at governance in a straight up way. I was struck by comments that I read that I didn't address, anyway, I just think that there could be good analysis, good solid analysis that lays out the comparisons of production cost benefits, of reliability benefits, of emission reduction benefits, of transmission expansion, and of governance. And I think that you don't have that information in front of you. And I think you need it to make a really sound decision.
Let me follow up on that. As an example, we now have in front of us a public service company resource planning case that has retail sales projection over the next 8 years that are anywhere from 5 times to 40 times greater than the historical growth rate since 2010. Given the comparatively small impacts associated with these market modeling efforts and the seemingly massive uncertainty we're facing with data centers, beneficial electrification, and federal tax and tariff policy, do you think the modeling is likely to be accurate enough to meaningfully help us? Said another way, we're struggling mightily to model the public service company system in Colorado under these certain uncertainties. Is it reasonable to expect we can model the entire West and get meaningful results out of all the noise given all this uncertainty?
I recognize the uncertainty. And I also have now remembered what my point was about that production cost estimate, and I'll come back and answer your larger question. My point was that estimate was based on an understanding of 478 megawatts of connectivity, when in fact what came out through testimony yesterday was there's about 30 to at most 180 megawatts of connectivity to external BAs. And I do think that it is important to undertake good production cost estimation for public services footprint and for the market participants. I think we had agreed that based on the limitations, either market model is probably going to give you similar production cost estimates, but there could be the biggest differences are where you're going to build out and what you get locked into long run. So I think that the issues that you're dealing with in the ERP relate very much to what we're looking at in this scenario, and we need good analysis in an application to join a market.
That's all I got. Mr. Burris, redirect.
Thank you, Mr. Chair. Just briefly, Ms. Kelly, do you recall just now having a conversation with Chair Blank about qualitative analyses?
Yes.
And do you have a view on whether a comparative analysis could also include a comparison of the qualitative costs and benefits of different market options?
Yes. Thank you. I believe that should be specified in an order, what those qualitative benefits and costs are that the commission is thinking about, and ask for comparative analysis, including those qualitative dimensions.
Ms. Kelly, I have no further questions.
Ms. Kelly, you can be excused. Thank you.
Thank you.
I have Mr. Lester next. Mr. Lester, can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Is anybody with you or communicating with you in any way?
No,
If that changes, will you let us know?
I will.
I think when I asked you to raise your hand hand icon came up. Back to you, Ms. Lowry.
Thank you, Chair. Good afternoon, Mr. Lester.
Good afternoon.
Could you please state your name and spell your last name for the record?
James Lester, Lester.
And by whom are you employed and what is your title?
I'm employed by the Colorado Energy Office. My title is Senior Advisor for Transmission, Climate, and Energy.
Did you cause to be filed in this proceeding cross-answer testimony and attachments which were labeled as hearing exhibit 800?
I did.
And if I asked you those questions today, would your answers be the same?
Yes.
Thank you. Those exhibits were admitted into evidence and Mr. Lester is available for cross-examination.
Mr. Denman.
I couldn't get my thing to work, turn on the mic and the video. Good afternoon, Mr. Lester. Nice to see you again.
It's good to see you.
I have a few questions for you to better understand your testimony. When did you first decide to prepare and file cross-answer testimony?
Well, after reviewing the company's direct filing, we did not believe that this expedited schedule would allow sufficient time for the commission or the parties to consider the company's application. And I think in light of the many complexities that were presented. And so due to the legislative session, other PC proceedings and workloads, we determined we were not able to file answer testimony by the deadline. So that's when we decided that we would file cross.
And you do understand that answer testimony in this case was due on April 29th, 2025?
I do.
And I understand that you joined the Colorado Energy Office in 2023?
Yes, correct.
What month do you recall?
May 1st of 2023.
And prior to that, you worked for the commission?
Yes, I was an advisor to the commission.
And thank you. And just for the sake of full disclosure, you and I had a chance to work together at the commission once upon a time, did we not?
Yes, we did.
On page 4 of your testimony, you describe what CEO is, and I don't want you to read any of that out loud, but in that section of your testimony on pages 4 and 5, you describe the what you call mission of the state agency Colorado Energy Office. Yes?
Yes.
And is it fair to say that CEO's mission does not include transmission reliability or improving transmission reliability or transmission planning?
No, I wouldn't agree with that characterization. I think
Okay, well, thank you. You don't bother to mention that here, though, do you?
no, I think when we are working on a transition to a clean and efficient electricity system, I think that transmission planning is certainly a part of that.
Thank you. Ms. Boulay, you can take down the testimony now. We may need later to refer to it. Can you take a look at page 9 of your testimony, just to refresh your recollection? You begin at the top of page 9 talking about proceeding 19M-0495E. You're familiar with
Yes,
that testimony? Did you participate in proceeding 19M-0495E?
I did not.
Thank you. Now, if you could kindly take a look at page 11 of your cross-answer testimony. About the middle of that page, you discuss proceeding 22R-0249E. And if you need to review that to refresh, that's fine. Please let me know when you're finished.
Yes, if we could pull that up. Thank you. Yes.
And you say on line 16, in response comments, CEO said something. Did you participate in proceeding 22R-0249E?
I did. I was responsible for response comments. Initial comments were filed by my colleague before I joined the office.
Okay, thank you. I'm reviewing my notes, Your Honor. And I think I have two more questions. Could you please take a look at page 22 of your cross-answer testimony here in Exhibit 800? Thank you. And you spend a couple of pages discussing your view on potential federal changes to GHG tracking and accounting. Do you recall all that testimony, Mr. Lester?
I do.
I'm not sure I understand what you're getting at here. And so let me inquire. Is in this section of your testimony, the Energy Office saying that the Commission should give in to changing whims of the current federal administration?
No, I'm not saying that.
And so do you believe that the Commission should follow Colorado law regardless of any contrary federal government arbitrary policies?
Yes, I believe that the Commission is required to follow Colorado law.
Okay. And do you follow the news?
I do.
And consistent with your discussion about changing federal policies, is it fair to say that a number of the executive orders and federal policies that are implemented by the current administration have been subject to massive litigation in the federal courts?
Some have, and I would agree that the others will likely face substantial litigation.
And are you familiar as an employee of the state of Colorado with the involvement of the Colorado Attorney General in challenging a number of federal policy changes and executive orders?
Yes, at a high level, I'm aware of some of the issues that the AG's office is taking on.
So let me ask you a hypothetical, Mr. Lester. If for some reason there were a significant change in federal policy that appeared to interfere with Colorado state policy or the mission of this commission, would you expect your state government to challenge that federal policy change or EO if it were in an executive order?
I believe they would attempt to challenge it, yes.
Thank you. I appreciate visiting with you, Mr. Lester.
Thank you.
Thank you, Mr. M. And Ms. Keene, I have 10 minutes.
We'll be waiving our cross of Mr. Lester. Thank you.
Thank you. Commissioner Goodman, questions for Mr. Lester?
I have no questions. Thanks.
Commissioner Plant?
I have no questions either.
Couple questions for you, Mr. Lester, about resource adequacy and how it could be impacted by these regional market decisions. Can we pull up what has been marked as hearing exhibit 1505? And Mr. Lester, you might recognize this as an electric resource adequacy annual report. That's I think I got the wrong exhibit number. If you can hold on. But 1502, I'm sorry, 1502.
Your Honor, before you go on, just as a matter of procedural inquiry, could I ask your counsel a question?
Yeah.
Ms. Rosati, are these exhibits that your client, Chairman Blank, is referring to in box.com available to the other parties?
They are in box.com.
They're in box.com. I don't know that they have been distributed to the other parties.
I've only moved, oh, I'm sorry. This is Stephanie. I've only moved over 1500 so far because it's the only one that we've used. But I can
Okay.
move this one over as soon as we're done.
And I was just curious, as at some point, I was going to bring this up at the end of the hearing, but it sounded like a good time now. Whether or not those documents will be available for all of us to review before we write statements of position.
Yes,
Okay.
the documents that get admitted will be available.
Thank you very much. And Mr. Chairman, I apologize for bringing this procedural matter up now.
Nope. I appreciate it. Ms. Kunkel, can you bring up hearing exhibit 1502? Do you recognize this, Mr. Lesser? And you can scroll down as an electric resource adequacy annual report prepared by your office.
Yes, I recognize it.
Can we turn to PDF page 12? I think it's, yeah. And if you can scroll down so we can see both, one more. Yeah, there you go. Do you see the line target PRM for both Tri-State and Guzman? And do you see how the Guzman one is 15 and the Tri-State one is 22?
Yes.
And under the status quo, are you aware of any binding state or regional standard for unregulated municipal utilities, distribution co-ops, or power marketers that would put in place a consistent approach to determining planning reserve margins in Colorado?
No, I'm not aware of that.
And presumably the same would be true for determining effective load carrying capacity values. Under the status quo, are you aware of any binding state or regional standard setting ELCC values for the unregulated utilities in Colorado?
No, I'm not.
And I don't mean to pick on Guzman Energy, and for all I know, they've addressed these shortfalls. But just looking at the capacity needs tab, it looks like Guzman has significant capacity shortfalls for 2026 to 2029. Would you agree?
Yes, I would agree.
And just in trying to roughly quantify this, I went to the ERP proceeding and looked at what's going to be hearing exhibit attachment, hearing exhibit 101, attachment JWI to volume 2 at page 176, which is the company's surplus capacity credit assumptions. Can we pull up what's been marked as, I think, hopefully hearing exhibit 1504? And do you see in 2026, it's $126.74 per kilowatt year. And in 2028, it's 130.69 kilowatt per year. You see that?
Yes, I do.
And you can take this down and go back to the other one. And, subject to later check, just multiplying the capacity shortfall numbers with these surplus capacity costs, the dollar impact of curing this capacity shortfall in 1 year, 2026, would be 28 million and 65 million in 2028. Subject to later check, would you accept that math?
Yes, I would accept that math.
All right. And again, given these shortfalls, are you aware of anything this commission could do now to require unregulated entities like these to meet their capacity need targets or to penalize them?
No, I do not believe so.
And are you aware of any other entity that has adequate regulatory authority to penalize an entity for potentially leaning on a balancing authority for capacity shortfalls in emergency situations?
I do not believe so.
All right. And under the markets plus and balancing authority tariffs, is it fair to say that all market participants would be obligated to comply with a consistent and uniform approach to planning reserve margins and ELCCs through good standing attestations with the Western Resource Adequacy Program?
Yes, that is my understanding.
And if a market participant failed to comply with the planning reserve margin, ELCC, or RA requirements, or RAP, is it fair to say that that would result in a penalty under Markets Plus and RAP? Is that right?
I am actually not certain. I know that would be the case for the RTO. And I'm actually not certain that would be the case for Markets Plus, but I would also trust your opinion on that.
So in terms of resource adequacy, it seems like the company's entry into Markets Plus could be a solution, or at least a partial solution, to some of the problems we may be seeing in this RA report. Is that fair?
I don't think I would go that far. This RA report was this was the first version of this RA report. The reporting consistencies was not across all the reporting entities was not consistent. In fact, Guzman at the time last year did not believe that they were required to file this information. So this was kind of compiled from some of their members, but we should have more accurate numbers in this upcoming report. So I wouldn't necessarily take this data as a complete understanding of resource adequacy in the state as of last year. I did want to clarify that.
Yeah, I don't disagree. And again, I have no idea whether Guzman is compliant or not, or whether they fix this. But I mean, theoretically, it does seem like under the status quo, no one, as you've testified, has authority over this. And under Markets Plus in the SPP RTO West, it seems like market participants may have to comply with RAP. Is that a fair characterization?
Yes, I think that's a fair characterization, and that is a benefit of a participation in a wholesale market, or in this case, a day-ahead market. That was
okay. And some of the dollar numbers or net costs and benefits that we're looking at associated with the production cost modeling, and just any comments on that?
I'm sorry, I don't know if it was just my network, but I kind of froze up during that last, or you froze up for me. It might have been on my end.
Yeah, I mean, we discussed that the sort of a rough value of the capacity shortfall in 2026 might be 28 million, 65 million in 2028. I'm just asking you if those numbers are as big or larger than some of the net costs associated with the production cost modeling.
I think that could certainly be the case. However, I don't recall seeing that type of benefit in the company's direct filing for this case. So I'd be curious to why they didn't include that as potential benefits.
Me too. We can take this down just a couple more questions. When the Weiss market goes away, Mr. Taylor testified that Colorado may no longer have transparent real-time hourly wholesale market pricing available for customers. Would you agree with that concern?
Yes, there's been a short amount of time that the company has been a member of Weiss.
And is it possible that the availability of real-time pricing data might help customers, third-party VPP developers, and others make better investment and usage decisions that could collectively assist Colorado to create a better load shape and reduce system costs?
Yes, that is possible.
And through Markets Plus, is it fair to say that there will be transparent and timely access to both real-time and day-ahead market prices that may not exist without Markets Plus?
Yes, for the participating utilities.
That's all I got. Back to you, Ms. Lowry.
Thank you, Chair. I just have a couple questions for redirect. Do you remember talking to Mr. Denman about proceeding 19M-0495E?
Yes.
Okay, and you testified that you were not part of you didn't draft or participate in that proceeding on behalf of CEO, right?
Correct. Not on behalf of CEO, but CEO did participate. Yes.
Okay, and did you review CEO's comments in that proceeding in writing your testimony in this proceeding?
I did, yes.
Okay, thank you. And you talked a bit with Mr. Denman about your testimony about federal government orders beginning on page 22. What was the purpose of referencing those federal orders in your testimony?
Well, I think all four of them are that we listed that have been that I listed that have been shown so far could have impacts upon this company's application, participation in markets, as well as Colorado's carbon emission goals. We've seen very recent actions by both FERC and DOE in response to some of these executive orders. So the discussion yesterday was that this is all speculative, but we are actually seeing real-time impacts from these executive orders on the electricity system.
Okay, and just one more. Do you recall your conversation with Chair Blank about real-time pricing?
Yes.
Okay. Has the company provided any evidence in this proceeding about real-time pricing?
No, they haven't.
Okay. Thank you. That's all the questions I have.
Thank you, Ms. Larry. Mr. Lester, you can be excused. Black Hills, I have Mr. Eggy. Can you remind me how to pronounce your name? Eggy. Can you put up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
No.
You can put your hand down. Is anybody with you or communicating with you in any way? If that changes, will you let us know?
Yes.
Thanks. Back to you, Mr. Sopkin.
Mr. Chair, Ms. Sabers, who was admitted pro hoc vice, will be handling Mr. Eggy's examination today.
Ms. Sabers.
Thank you, Chair Blank. Mr. Eggy, can you state your full name and your job title for the record?
My name is Eric Eggy, and my title is Director of Electric Strategy, Planning, and Policy.
And are you testifying today here on behalf of Black Hills Colorado Electric?
I am.
And did you cause to be filed in this case direct pre-filed answer testimony that was originally marked as Exhibit 500 with attachments EME 1 through 5, but was revised to be reflected as Exhibit 700, attachments EME 1 through 5?
Yes.
And if I were to ask you this questions identified in that testimony here today, would you have the same answers? I am tendering Mr. Aggie for cross-examination.
Mr. Denman, I have 15 minutes.
Thank you, Your Honor. Mr. Eggy, nice to see you again.
See you.
It's been a while. I have only a few questions for you. Do you agree that the electric transmission systems of Black Hills and Public Service Company are interconnected in Colorado?
Yes.
And because of that interconnection, each system is able to transfer electric energy back and forth to each other. Is that correct?
Correct.
You, in your conclusion, and this is on page 21 if you need to look at it, you say that you believe a prudent course of action would be to delay joining Markets Plus until what you call a market-to-market coordination structure has been designed and approved through the SPP, RTO, and Markets Plus stakeholder processes. You see that? You're familiar with that testimony?
Yes.
Mr. Eggy? Okay. So in your view, how long would it take to have a market-to-market coordination structure to be designed for the purpose you suggest?
I don't know exactly how long it would take. A lot of that depends on the stakeholder process and how quickly the stakeholders want to work that through, but I anticipate it would be a couple of years.
Okay, well, my first question was how long would it take to design that market-to-market coordination structure? We'll get to the other later.
Yeah, I see that as kind of all encompassing, as that's the process for the design, is you have to go through the stakeholder process and then also moving on to approvals and implementation.
Okay, so you said a couple of years.
Possibly, depending on how ambitious and how important this topic is to the stakeholders.
So does that mean if this topic is not ambitious or important to the stakeholders, that it could take longer, like another couple of years?
It's possible.
Okay. Thank you, Mr. Eggy. Good to visit with you.
Commissioner Gilman, questions?
Hi, Mr. Iggy. Really just one question for you. I know in public services testimony, they've essentially stated that Black Hills Electric will basically have to decide if they either become a Markets Plus participant or hire public service or another third party to be its market participant. Do you agree with that summary?
Yeah, I think I agree that Black Hills is going to have to make a decision on if we want to become a direct market participant or go in a different direction. But my understanding is that if the public service company balancing authority enters or becomes a market participant in Markets Plus, then our load, the Black Hills load and generation would have to be registered in some form or fashion within the market.
Okay. And I understand Black Hills has some concerns about what costs of participation would flow through to you.
That's one of our largest concerns or questions that we have is it in particular what costs would be borne or flow through to our customers as as part of our balancing authority agreement with public service, not only from a administrative fee for Markets Plus, but then also on the other costs for implementation that have been discussed earlier in the proceeding.
And do you have any sort of granularity or insight into what those fees would look like for Black Hills Electric?
We don't have any specifics. We haven't gotten that detail of information from public service yet as to what magnitude of costs that we could expect to have flowing through to our customers.
Okay. And this probably somewhat depends on the answer to the prior question, which you don't know, but has Black Hills Electric been able to do any analysis as to the net cost or benefit to your customers of kind of the situation you would be in if you were kind of by default moved into Markets Plus in this way?
Yeah, we don't have a specific analysis that shows that. Some of it is dependent upon understanding what the cost picture looks like.
Okay. I think public service characterized that there would be significant benefits to Black Hills Electric. Do you agree, disagree with that characterization, or just don't know enough to know?
I feel confident saying that there likely would be benefits. Significant might be a bigger question or might need to be defined a little bit better. I think our previous experience in the real-time markets that we've participated in with public service, whether it be the JDA or the Weiss markets, we have seen benefits. So I think those markets, at least the real-time markets, have proven that out. I think we have less clarity or certainty on what additional benefits the day ahead and the unit commitment would bring exclusive to the public service BA. And then trying to understand what that looks like relative to the cost. So I guess maybe I'd summarize it as I think there's certainty that we'd see some level of benefits. How that level compares to the cost, I think, is the piece that we're not as certain about.
Okay, thanks. Those are my only questions.
Thanks, Commissioner Goman. Commissioner Plant?
I have no questions.
Neither do I. Redirect, Ms. Sabers.
Just a couple of questions, Chair. Mr. Eggy, could you maybe, you remember the conversation you had with Mr. Denman about the market-to-market optimization and some of your comments in your pre-filed direct testimony about that market-to-market optimization?
Yes.
Could you please maybe share with the commission why Black Hills thinks that the market-to-market optimization is a key component to looking at the Markets Plus opportunity?
Your Honor, I object. That's beyond the scope of my cross. I asked him about his discussion about a market-to-market coordination structure. I did not ask him about market optimization.
I think those are hand in glove in the same conversation, but if you would like me to rephrase it, I'd be happy to
Well, I
rephrase?
I would like you to rephrase. I thought that was beyond his original question too.
All right,
Thank you,
so
Rhonda.
the conversation that you had was, I think, the timing of market optimization, because your testimony spoke to the question of a potential delay to allow for a market, and I'm going to say optimization in because that's what's in my head. A market unit commitment solution could be put in place. Do you recall that testimony? Could you explain the basis of that statement or the reason for that statement?
Yeah. Absent that market-to-market coordination, it's my view that there's, because of the limited transfer capability between the Public Service Balancing Authority and other Markets Plus balancing authorities, that market-to-market coordination is a critical component to really be able to gain market benefits that we feel are certain enough and sufficient enough to overcome the cost and ensure that we do have a net benefit, just given the size of, the lack of transfer capability between other Markets Plus participants, essentially to justify the added Markets Plus expense.
And then you also had a question, I think, from Commissioner Gilman about where Black Hills was at in its analysis of costs and benefits for its customers. Just from a timing perspective, is the outcome of this proceeding important to Black Hills' decision on Markets Plus?
Yes. If, our decision to join Markets Plus is really dependent upon the balancing authority. We can't make that decision independently because we're not a balancing authority.
That's all the questions I have, Chair. Thank you.
Thank you. You may be excused, sir. Thanks. Why don't we take a break till 3 p.m. and we'll come back with UCA's witness and Dr. Dalkey. So 3 p.m.
Hi, Patrick. Can you hear me all right?
Mr. Rubin, did you have a matter?
Yes, I was hoping to just raise a brief motion to strike from the record the testimony from WRA witness Welters regarding hearing exhibit 1500. Holy Cross did not have a chance to review that hearing exhibit prior to the hearing, and I'm just concerned under Colorado Rule of Evidence 401 and 403 that the foundation laid for that exhibit, and given that it was from a past docket, may be prejudicial. I'm not sure that the relevance to this docket, Markets Plus docket for public services, is really crucial.
I don't disagree with that. I assume, Mr. Brasso, you'd be okay with that.
No objection from WRA, Mr. Chair.
Yeah, I'd sustain the motion to strike. I would agree with you that there was not a proper foundation.
Thank you.
Ms. Henry Sermos, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
Mr. Wittgenstein, back to you. Somehow you're muted, sir.
Can you hear me now?
No, now we can hear you.
Great, thank you. Ms. Henry Sermos, can you hear and see me all right?
Yes, I can.
Thank you. Can you please state your full name?
Leslie Henry Sermos.
Are you able to speak a little bit louder or maybe closer to the microphone, please?
Okay, I'll try. My name is Leslie Jennifer Henry Sermos.
Thank you. And what is your occupation and where do you work?
I'm a rate and financial analyst for the Office of the Utility Consumer Advocate.
Did you prepare the answer testimony and attachments that have been labeled as hearing exhibit 400 revision 1 in this proceeding?
Yes.
If I ask you the questions contained in your testimony here today, would your answer still be the same?
That is correct.
Thank you. Ms. Henry Sermos is available for cross-examination.
Mr. Denman, I have 30 minutes.
Thank you, Mr. Chairman. Ms. Henry Sermos, am I pronouncing your name correctly?
You are.
Thank you. And I appreciate your getting closer to your mic because I had trouble hearing you in the beginning. Thank you. Let's start with page 6 of your answer testimony hearing exhibit 400. Thank you, Ms. Boulay. There you start talking about what you call the JTS application. And JTS stands for Just Transmission Solicitation, does it not?
That is incorrect. It means just transition solicitation.
I think I said just transition solicitation.
I heard you said transmission, sorry.
No, I said, well, these are the difficulties of remote hearings, but we're communicating it. We agree that what JTS stands for then, do we not?
We do.
Okay, and it's true, isn't it, that you're a witness for the UCA in the JTS docket?
That is correct.
And would you agree with me that the JTS application was filed by Public Service Company on October 15th, 2024?
I believe that's correct.
And the Markets Plus application, however, was filed on February 14th of 2025, wasn't it?
Yes.
And would you agree that the hearing in the JTS case starts on June 10th, 2025?
I believe that is correct.
Okay. And do you also agree that the JTS application was filed under a couple of the Commission's resource planning rules, that is Rule 3603 and 3617?
Yes.
Okay. And however, the Markets Plus application, about which we're here today, was filed under the regional electricity market participation rules, specifically rules 3753 and 3755.
Yes.
Okay. And your testimony about the JTS application and your various opinions about that case do not respond directly to any direct testimony filed by Public Service Company in this Markets Plus case, do they?
This proceeding is directly tied to the JTS in UCA's opinion, due to the increase in capacity needs and transmission planning that is required for both proceedings. So we do see a link, though not directly regulatorily required. It is, as far as planning for transmission and for generation resources, considered by UCA as related.
Your Honor, I move to strike the answer is not responsive to my question. I did not ask her opinion on the link between these two cases. I asked her what direct testimony of Public Service Company that she was responding to by talking extensively about the JTS case.
Mr. Witterstein.
I believe she answered the question to the best of her ability.
No, she did not, Mr. Witterstein, with all due respect. She answers different. I'm sorry, Your Honor.
Yeah, would you rephrase your question? I'm not going to strike at this point. I think we can give it the weight it deserves, but can you rephrase your question?
I believe the question was clear. I'm prepared to move on.
Okay.
So we don't take the Commission's time with this. And on page 8, you've got several questions and answers regarding the JTS case. And again, is it true that you're not responding to anything in your answer testimony on page 8 that was raised in a direct testimony of any Public Service Company witness?
Could you please pull up that page so I can review it before I answer?
Sure.
Thank you.
Ms. Tracy, thank you.
And could you repeat your question?
Okay, in those questions and answers, beginning on line 1 and going down to line 17 on page 8, isn't it true that your answer testimony here does not respond directly to anything raised by Public Service Company in its direct testimony in this case?
The company did not address JTS issues within this proceeding.
Thank you. And as far as you know, the UCA has never filed any motion to consolidate the JTS case with the Markets Plus case. Isn't that true?
We have not.
thank you. You have a discussion beginning on the bottom or mid of page 8 over on the top of page 9 about ELCC. Can you tell me what ELCC is standing for?
It means the electricity, effective load carrying capacity.
Okay. And the ELCC is an issue in the JTS case, isn't it?
It is.
Let's turn to page 12 of your answer testimony, Ms. Henry Sermos. At the top of that page, the question is asked about oversight of transmission investments. And you make a recommendation that a quote specific transmission impact scenario should be required of public service company by the commission. Is that a fair summary of what you're saying there?
I would say that this scenario would be represented in a study. What we're recommending here is that the commission require a holistic study, which includes not just those facilities or transmission facilities that will be that are in the process of being approved through the JTS, and include in that any transmission associated facilities that are approved as part of Markets Plus when that eventually happens.
Okay, so now I'm confused. Are you recommending that in the JTS docket, the commission order public service company to do a Markets Plus specific transmission impact scenario?
No, that is not what I'm saying. Within this proceeding.
Oh, so in this proceeding, that's what your recommendation is?
That is correct.
Okay, so can you point me to a commission transmission planning rule that requires the filing of a quote transmission impact scenario?
I cannot at this moment.
Well, let me ask you another question. Have you ever reviewed commission transmission planning rules, particularly Rule 3657?
No, I have not. I have not been part of other
Thank you.
transmission review proceedings.
Thank you, ma'am.
For the commission.
Let's talk about your recommendation regarding recovery of costs through the ECA. And I don't know that we need to look at anything specific in your testimony, but are you sufficiently familiar with the operations of the UCA to know that the UCA receives and reviews quarterly ECA filings made by public service company?
Yes.
And do you agree also that the UCA regularly receives and participates in the annual ECA prudency review filings?
Yes.
And during those reviews by UCA, isn't it true that an analyst, maybe not yourself, employed by the UCA engages in a deep scrutiny of those filings and what they conclude?
Yes.
Okay. On page 14, starting on line 19, and Ms. Boulay, you might want to pull that up, please. You, on line 22, well, let me first, why don't you read to yourself the answer that goes from the bottom of page 14 over through the top of page 15 and tell me when you're finished.
Okay.
On line 22, you say the phase 2 costs are not directly caused by actual market transactions. Is that still your belief?
These costs are technically related to actual market transactions. However, in this case, when the company starts cost recovery, there will not be associated to actual transactions that the company is doing, since the company will not start, since Markets Plus will not start operations until 2027.
Okay. Ms. Boulay, would you pull up from box.com what's been marked for identification, hearing exhibit 108? Now, have you seen this document before, Ms. Henry Sermos?
Yes.
And you're in fact the sponsor of the answer.
That is correct.
And isn't it true that the response was costs that are incurred after the company joins Markets Plus and that are directly caused by actual market transactions may be appropriate for cost recovery through the ECA?
That is correct. I would like to state the word after.
Thank you. I appreciate your answer. I move for the admission of hearing exhibit 108, Your Honor.
Mr. Wittershine, any objection?
No objection.
So moved.
Thank you. Let's turn now to your discussion on page 15, starting on line 7, about the Weiss proceeding. It's 25A-0075E. And are you familiar enough with that case to know that that proceeding was settled? It resulted in a settlement agreement?
I am aware that it was settled, yes.
And the UCA was a signatory of the settlement agreement?
That is correct.
And PUC approved that settlement?
Yes.
But you were not a witness for UCA in that proceeding, were you?
No, I was not.
Okay, thank you. And on page 16, the next page, you discuss the outcome of a commission rate case that's you cite to a decision C24-0778. Is that correct?
That's correct.
So is it your testimony that the commission should rely upon the decisions in the Weiss case settlement and in the 2024 gas rate case as precedent?
Though I'm not an attorney licensed in the state of Colorado, I am aware that these decisions do not create a precedent. However, it was I wanted to reference, and I reference these decisions here just to remind that these costs have not been included as part of other writers.
No, I appreciate that you may not be licensed in the state of Colorado, but you are an attorney, aren't you?
Yeah.
Okay, I thought so. So you're just arguing that these are sufficiently precedential decisions, the commission should follow them?
I am not suggesting that they're precedential. I'm referencing them.
Oh, okay. Well, thank you. I appreciate the clarification. Your Honor, thank you. I'm finished.
Thank you. Ms. Keene, 15 minutes.
Thank you. I'll be waiting, Craft.
Thank you. Commissioner Gilman, questions for Ms. Henry Sermos?
No question.
Commissioner Plant?
I have no questions.
And neither do I. Mr. Wittershine, any redirect?
Yes, a brief redirect. Thank you, Your Honor. Ms. Henry Sermos, can you still hear me?
I can.
Thank you. Do you recall your conversation with Mr. Denman about what you addressed in the company's direct case in your answer testimony?
I do.
Do you have any comments on why you addressed gaps in the company's direct case concerning the modeling of Markets Plus in the JTS?
Yes. During the JTS proceeding, multiple parties also referenced some issues relating the company's general forecasting concerns. So in our analysis, we did notice that market participation was not one of those elements that was considered during the forecasting and the modeling that was produced by the company. So not seeing that referenced here or having any consideration for Markets Plus within what the company sees as their load forecast and as their potential available capacity forecast was a little concerning. We would have hoped to have better coordination and more information regarding Markets Plus in the proceeding.
Do you remember speaking with Mr. Denman about your recommendation for a transmission impact scenario?
I do.
Can you explain why UCA recommended the company file a transmission impact scenario in the future?
We're recommending this because we think that transmission planning needs to be a holistic process, and within that, we don't see this here nor in the JTS, which is why we think that the company should conduct a general assessment of their transmission capacity prior to making all these investments that are considered not just within the JTS, but also in this proceeding. That at this time, we don't really have an estimated amount of the required investment or any information of design or if it will be coordinated or not with any of the investments within the JTS.
Ms. Henry Sermos, do you recall hearing Exhibit 108, which was Discovery Response UCA 14, which Mr. Denman pulled up earlier?
I do.
Can you explain why market transactions after the company joins Market Plus may be appropriate for ECA recovery and how that is consistent with your answer testimony?
Well, actual transactions will be part of what could be considered as fuel or energy or power purchases that the company has to make to meet its demand, and therefore could be considered one of those variable costs that are included in the ECA. Those actual purchases of power and energy. However, what we have here with administrative fees and all these additional costs in phase 1 and phase 2 are fixed costs, and therefore would be better suited to be recovered through base rate than an alternative base rate recovery.
Thank you, Ms. Henry Sermos. No further questions.
Thank you. You may be excused, ma'am. Thank you.
Thank you.
Miss Dr. Dalkey, are you out there? Can you hold up your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
You.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
I will.
Back to you, Mr. Crakes.
Thank you, Mr. Chairman. Dr. Dalkey, did you cause to be filed in this case the document that's been marked as Hearing Exhibit 500, the answer testimony of Stephen Dalkey?
Yes.
And if I were to ask you the questions in that document today, would your answers be the same?
Yes.
Thank you, Mr. Chairman. Dr. Dalkey is available for cross-examination.
Mr. Denman.
Thank you. Dr. Dalkey, good afternoon.
Good afternoon.
I don't know if we've ever met. although we may have passed during the pandemic at the same employer. I'm Steve Denman. I'm an attorney for Xcel Energy, and I represent public service in this case.
Nice to meet you, Mr. Denman.
Thank you. Did you have opportunity to review the rebuttal testimony of Stephen Berman?
I did. If you have specifics, it might be better to pull them up, but I have reviewed that rebuttal testimony.
Good. I don't think we'll need to do that. And are you familiar with the alternative proposal that Mr. Berman made toward the end of his testimony?
Can you be a little more specific on an alternative proposal?
Well, then maybe we're going to need to show.
You might be talking about load ratio share, but I think there was other proposals or thoughts. So I just want to confirm we're thinking of the same thing.
Well, let me try to clarify, and if we need to pull up his testimony, he made an alternative proposal about ongoing oversight by the Commission of Public Services participation in Markets Plus in the event the Commission grants this application. That's the part I'm asking about.
Sure, we can proceed, and if we need to clarify, we can address that as we go.
And does the staff have a position on whether or not Mr. Berman's proposal for oversight of participation in Markets Plus would be an acceptable process?
Just respond to your question, Mr. Denman. Assuming that you're referring to a proposal in Mr. Berman's testimony that is focused on an alternative guardrail using a metric called load ratio share, in contrast to the metric slash guardrail we proposed, focused on a cap on annual market administrative costs.
Yeah, specifically, that's what we're focusing on.
Great. Yeah, I appreciate Mr. Berman's counter proposal. If I can provide a few thoughts. I think I understand where the company is coming from in thinking through why a load ratio share could be a useful metric. So essentially, subject to check, Mr. Berman counter proposed a guardrail that if public services load ratio share in Markets Plus were to exceed 20%, then that would be a trigger for additional commission and stakeholder review of the costs and benefits looking forward. The load ratio share is impacted by the amount of load public service has in the future market relative to other market participants. So if, for example, a large chunk of the market were to drop prior to market go live or at any time going forward, PSCo's load ratio share would increase. Currently, I believe the PSCo's latest estimate, based on the best information we know at the time, is public services load ratio share is around 13%. Mr. Berman proposed a 20% kind of trigger. If load ratio share LRS were to increase above 20%, that would trigger a review. That has some advantages because it adjusts to the market size while getting at one potential concern, which is that if other large entities drop, then public services share of total costs would go up, and that would be something of concern, right? It could increase costs relative to benefits more than we have based on current estimates. I think it's potentially a useful idea to consider for that reason. One possible concern with that approach, in contrast to what staff proposed, which is just kind of a simple dollars per year cap on market administrative costs, is a possibility that if SPP were to come back to its members and say, well, actually this 150 million plus $75 million a year cost estimate, we actually, now that we're getting into it, this is actually going to cost everybody 200 or 250 million upfront, right? Even though public services, in that case, even though public services load ratio share doesn't change, our share of the cost still goes up and could impact the costs and benefits. So I think there's two potential moving targets to think about. I think the load ratio share is a nice proposal from the perspective of it adjusts, and is more focused on PSCo's relative share of the market. It just may not get at that secondary case where if the load ratio share were to stay the same, but costs were to go up anyways, that still might be something that we want to consider. If that would be okay.
Thank you. In Mr. Berman's alternative proposal, the staff would get notice of participation by public service in Markets Plus through the reporting function that is embedded in the what I'll call the OWM rules. Isn't that true?
I'll take your word for it, subject to check with Mr. Berman's testimony.
Well, the commission has a rule in the OWM rules that call for reporting on matters that are within
Your Honor, or Mr. Chairman, I'm going to object. Mr. Dalkey has said he doesn't have any personal knowledge of this, and Mr. Denman shouldn't be testifying here today.
Well, I'm certainly not testifying, Your Honor. I'll withdraw the question then. You're assume that the company will be filing reports with the commission regarding its participation in Markets Plus if this application is granted. The staff would be reviewing the contents of those reports, would it not?
We would, yeah.
And if there were concerns about increase of cost, regardless of whether the market ratio looked okay, or the load ratio that you discussed looked okay, would the staff then raise concern informally with Public Service Company about that concern about increasing cost?
Yeah, in this case, we certainly could, Mr. Denman. I think what we were getting at in our guardrail proposal, and my impression of Mr. Berman's counter proposal is that we're actually considering something a little bit more proactive in that, if this would trigger an additional kind of re-review, whether that is a component of a future ECA prudence review or some other procedural mechanism, perhaps remains to be worked out. But I think we're thinking a little more proactive. Sometimes it's better to catch these things up front than fight about, retroactive prudency later.
Isn't that the trick? So if there were concerns the staff identified in reports filed by Public Service, one procedural vehicle during which you could raise those concerns is the ECA prudency review process, correct?
Yeah.
And if, for example, the staff thought there was a violation of a commission order by Public Service Company, the staff could initiate a show cause complaint proceeding, couldn't it?
Probably. I've worked with my lawyers on that one.
Certainly. And also, Mr. Berman's alternative proposal addressed a process for the circumstances under which Public Service Company might exit or withdraw from Markets Plus if necessary. Do you recall that?
Yeah, I recall him discussing that.
And the process and the alternative proposal he made would also provide a process for the commission to use in the event Public Service decided to withdraw from Markets Plus, would it not?
I think he and I both contemplated this. I don't think we're at a point where we have a defined process out of either proposal,
Okay.
but I think we're approaching that in some of these discussions.
Okay, thank you. I have a couple of other questions for you at the beginning of your testimony. Let's go to page 6 if you could, and Ms. Boulay, if you could pull that up. On line 17 of page 6, you begin talking about GHG tracking. If the commission decides this case in Public Service's favor, isn't it true that staff would monitor the GHG tracking under the Market Plus protocols?
Yes, we would.
And assuming the same approval, on the next page, you talk about market seams coordination. Wouldn't the staff also closely monitor seams performance on a going forward basis?
As close as we're able, given everything else going on.
Thank you. Turn now to page 25. And on line 9, could you read lines 9 through 11 to yourself, please?
Done.
This instead model-based analysis with a market footprint that you suggest, do you have a sense of how long such a new study would take?
Potentially take quite a while. On that, we stopped short of actually recommending a restudy. Would have been nice to have as part of the initial application, but to your question, it potentially could take several months.
Okay, well, you said quite a long time. So you're talking about months, not years?
I would think so.
And
yes,
months could be like 11 months is sort of a year.
There's a lot. It depends, Mr. Denman. If, for example, the consultant that you previously used could quickly update the existing model, it could be on the shorter end of months. If you commission a new analysis from scratch, it could take more time. It depends on the person and the model and the starting place.
In your work for the commission, have you ever heard of the phrase paralysis by too much analysis?
Yep.
And so is there a danger of recommendations for additional study or more study, or rejecting this proceeding with having a new proceeding with more study, a way that one could potentially run into the problem of paralysis by too much analysis?
Yeah, I'm not going to speculate on the extent to which that's a danger and risk here, Mr. Denman. In my testimony, we didn't make that recommendation.
Thank you. We talked a little bit earlier about reporting, and on page 26 is what I had in mind at line 8. You talk about commission rules require reports on market participation. That's the kind of reporting I had in mind. And you recall our earlier discussion about reports?
I do.
Okay, and so if when Public Service Company makes a report about its market participation, isn't it true that the staff receives that report and reviews those reports?
That is true.
And by that reception and review of Public Service's market participation reports, staff will have a fairly good idea of on an ongoing basis, or how things would be going in Markets Plus, for example, if this application were approved.
Yeah, I'm not sure. I think that depends, on the details in those reports. You can meet a rule requirement technically while not, while not giving a lot of insight. One of the challenges we had with this application is we don't really have, diving deep into the modeling underlying the benefits assessment. We didn't really get a good sense of what was actually going on. So the starting place isn't a promising start from my perspective to get a good understanding. So I'm not sure how helpful the ongoing reports will be to that question.
When, oh, I'm sorry, I thought you were finished.
I am.
Okay, thank you. When the staff receives a report, and I'll ask you if you agree, there are a lot of reports that Public Service Company files with the commission. Is that right?
That's right.
And when the staff receives a report and it has questions, isn't a common practice for you to then make inquiry of your counterparts at Public Service to obtain more information that you might have had a question about?
Yeah, yeah, we can do that.
Let me check my notes here. Okay, let's look at page 27. I think that's close. You begin a discussion about potential uncertainties. Do you need to reread that testimony on pages 27, the top of 28 to refresh your memory?
Not at this time.
Okay. So I'm concerned about what you really mean here. Are you saying that the commission should just give in to any whims or changes by current federal administration or federal agencies about GHG tracking?
You won't see that language in my testimony, Mr. Denman, nor was it implied.
And that's not what you were getting at here, is it?
No, what I'm more getting at is it's a potential reality around us that we should not blind ourselves to. You know, we even if there's checks and balances on our federal government and litigation opportunities, if things cross legal lines, you know, the FERC oversight over these markets, the DOE and President Trump have ability to issue executive orders and FERC rulings that could make things pretty complicated potentially, even in the interim of you know, the possibility of litigation playing out over periods of time. So that's the sentiment.
And I appreciate that. Were you tuning in to the hearing when I had a similar discussion with Mr. Lester?
I was.
And as a state employee, do you disagree with anything Mr. Lester said?
No, I don't disagree with anything Lester said as a state employee.
Thank you. I have perhaps one more question or two for you. Have you been involved in staff's review of ECA filings and ECA prudency review filings?
It's been a few years, but I was involved in one several years ago.
Okay, and when the company files a quarterly ECA filing, the staff receives that filing and scrutinizes it to make a determination of whether or not costs that are recovered are not only mathematically correctly calculated, but are reasonable and prudent. Isn't that true?
Yes.
Okay, and so if staff had a concern about costs that were being recovered through the ECA, if assuming that the Markets Plus application is granted, you would have that opportunity through that process to raise concerns that you might have, correct?
We would have that opportunity. I don't think that's a replacement for thoughtful, proactive guardrails.
Okay, thank you.
Sure.
Appreciate visiting with you, Dr.
Likewise.
Dalkey.
Thank you, Mr. Denman.
Thank you,
Ms.
Your Honor.
Keene.
We will
Ms.
also
Keene.
waive against Dr. Dalkey. Thank you.
Thank you, Ms. Keene. Commissioner Gilman, questions for Dr. Dalkey?
I have no questions. Thanks.
Commissioner Plant?
I have no questions either.
Dr. Dalkey, I have some questions for you. Are you generally aware that there was a Colorado PUC trial staff report to the Colorado legislature on regional markets that was developed in response to a 2019 statute called the Colorado Transmission Coordination Act?
I'm aware of that, yes.
Can we pull up the report, which has been marked as hearing exhibit 1505, and turn to the middle of PDF, page 25? Well, actually, go to the cover page for a second. Do you recognize that as the trial staff report, Dr. Dalkey?
I do.
All right. Can we go to page 25 in the middle? And I'm not going to quiz you about the details of the modeling too much, but do you see that the Colorado PUC trial staff hired Siemens PTI to conduct a study on the costs and benefits of alternative regional electric market structures?
I see that.
All right. Can we go to page 7 in the PDF? It's page 2 in the executive summary. And do you see the second, can you scroll down? Do you see the second sentence that says participation of Colorado electric utilities in energy imbalance market could deliver on the order of $50 million in annual savings to Colorado, approximately 1% of the total electric revenue requirement of $66 billion. Do you see that?
I do.
And since this modeling is statewide, public service company realize maybe a little more than half those benefits. Is that a fair back of the envelope thought on this?
Perhaps.
Okay. And given that there's admin costs to joining a market that offset these, I guess, relatively small benefits, then the Siemens PTI modeling sort of kind of maybe confirms what public service company found, which is that the benefits with a limited footprint and are small, roughly equal to or maybe even below the production cost savings for some time. Is that fair, or would you say that different?
I might ask you to clarify. So are you saying these benefits are small relative to what we know about the administrative costs? Is that what you're getting at, Chair?
Yeah, basically what you found sort of aligns with what public service company found.
They're similar orders of magnitude.
Okay, thanks. And you go to further down the report, and do you see that full participation in an RTO could deliver approximately $230 million annually, or 4 to 5% of the total statewide revenue requirement, with a broader day-ahead market realizing some unquantified part of that? Do you see that?
I do see that.
And these savings, modeled savings, might arise from better optimizing unit commitment, transmission utilization, and reserve sharing over and above optimizing dispatch. Is that fair?
That's fair. And subject to check, I may add that there was possibly one more, which was kind of integrating this into the investment decision making, like the lower reserve margins and how that impacts the build decisions of needed resources.
Appreciate that. And is it fair to say that these more dynamic benefits might not be quantifiable in the production cost modeling that Western MEG did, or even attainable in the day-ahead market structure without much more development? Would you agree with that?
Yeah, some of these benefits, like especially the latter one, I don't think are obtainable in just a day-ahead market. And I think the production cost savings of more real-time and day-ahead dispatch is where the similarities overlap here.
Okay. And finally, can you read the last paragraph on this page? And I think what it says is that the study essentially found that it didn't matter whether Colorado looked west to CAISO or east to SPP, that the key to obtaining the benefits was to participate in a larger footprint and to optimize among a broader set of factors. Is that fair?
Yeah, I think that's a fair high-level statement.
All right. So let's talk about long-term goals. And one objective for this commission might be to do everything we can within reason to realize that $230 million a year benefit, as you say, based on optimizing dispatch, unit commitment, transmission utilization, reserve sharing, and resource investment across a bigger footprint. Do you believe this could be a critical goal of this commission, given the size of those potential savings?
I think it's worth considering, given the opportunity in front of us. I think, as you all know and has been discussed, there's potential trade-offs, at each step that are worth considering alongside this possible, prize.
Okay. With those, and just one more thought on goals, if we can create a uniform set of binding resource adequacy standards, GHG emission tracking and reporting protocols, and transparent wholesale market prices to guide customer usage decisions, that could potentially be a real improvement over the status quo in terms of, goals of this process. Would you agree with that?
I would, yeah. I mean, I think in general, your intuition's right to think through these what are now in front of us non-quantified benefits. So I'm not, I'm tempted to just talk more about that, but I will stop because I think, the record's already in front of us.
All right, appreciate that. With these goals in mind, it seems like there are 4 potential paths forward for the Public Service Company Balancing Authority. 1, public service company could seek to join CAISO EDAM. 2, the company could seek to join SPP RTO West. 3rd, public service company could do nothing now and continue to analyze the alternatives, potentially staying out of any regional market. Or 4, this commission could approve the current application and PSCO could move forward with joining Markets Plus. Do you see any other potential outcomes in this case beyond these 4?
No, I don't. We've thought through maybe just a wrinkle on the do nothing approach, that if there's no market in the interim, something like a JDA locally could be re-implemented. Beyond that, I agree with those 4 general options.
Okay. And from Mr. Taylor and Mr. Turner's oral testimony, in my own general sense, it seems like one of Colorado's 2 balancing authorities, the one run by WAPA, is committed to SPP RTO West because it and the other market participants have load and generation in both SPP RTO East and West. Is that generally consistent with your understanding, or would you say it different?
I have no reason to say it different. Sure.
Okay. And let's talk about CAISO EDAM. And we can, if we could pull back that CTCA study, I think it was 1505, at PDF page 8. And there's a full paragraph starting with finally in the near term. Can you just read that to yourself for a minute?
Yep, I read it.
All right. So given this reality, is it possible that Colorado would be better off having one operator running both the RTO and day-ahead markets with our 2 balancing authorities, as compared to having a CAISO SPP seam running down the middle of Colorado? Said another way, doesn't it seem more likely that Colorado might have a better chance in the future of realizing that potential $230 million a year in benefit by optimizing, all the issues we talked about, unit commitment, transmission, reserve sharing, investment, with a single market operator across both our balancing authorities. Any thoughts on that?
All else equal, I think a single market operator can help reduce some complexity, Chair. I'm not prepared at this time to agree to those other lofty components of your statement.
Fair enough. Let's talk about our SPP RTOS. Can we turn, well, actually, while we're still here, do you disagree with anything staff said to the legislature a few years ago?
Chair, I helped write this report, and at this time, I still don't disagree with anything said in it.
Okay, I didn't know you wrote it, but let's talk about SPP RTOS. Can we turn to PDF page 9? Can you read to yourself the last two full paragraphs on that page? So if you can go down to the last two, yeah.
Okay, I've read it.
Is it fair to say that this report acknowledges the concerns raised by Mr. Taylor and the company about joining SPP RTOS, at least until FERC has more fully addressed these interconnection, transmission cost allocation, and other concerns, which particularly around interconnect queue backlogs may have gotten much worse over the intervening years? Thoughts about the relevancy of this?
It's fair to say that these two paragraphs discuss those two concerns around interconnect and transmission planning oversight and authority, Chair. And I don't believe that those issues have materially been resolved or have gotten easier in the intervening years between this report drafted when this report was published and today.
And you see that this mentions transmission cost allocation. Do you see that? Where is it?
Yep, the second to last sentence, I believe, Chair.
Yeah, and I mean, I tried to talk briefly with Mr. Turner about highway SPP, highway byway. Do you have any familiarity with that?
At a very high level.
Is it fair to say, to the best of your knowledge, is it fair to say that it allocates transmission costs based on peak demand?
I'm not sure about that detail, honestly.
Okay. All right. Let's talk about your proposal to do additional modeling. It seemed like trial staff already engaged PTI Siemens and did the modeling 5 years ago. Is it possible that we'd be pushing ourselves back years by remodeling the entire West again, particularly amid all the data center, beneficial electrification, and federal tax, tariff, and environmental policy uncertainty? I'm struggling to see why it'd be useful to go back and redo all this again, especially since you have already mainly agreed that the qualitative issues still apply.
Yep. So I think I agree with the challenges of remodeling, getting into paralysis by analysis concerns. We had a lot of questions and concerns about the modeling that was presented in this proceeding underlying the production cost benefits. And perhaps just to clarify the opening part of your question, Chair, staff didn't recommend additional modeling.
Okay, fair enough. Is it fair to say right now in real time, most utilities in the West are choosing between one of these three market alternatives, CAISO, EDAM, SPP, Markets Plus, and SPP, RTO West?
Yes, and I would just add the fourth, which you mentioned earlier, which is just to sit tight.
Okay. Do you get the sense of, it seems like most utilities are jumping, would you agree with that, into one market or another, or you would not agree with that?
I'm not sure. You know, I'm not up to date on all of the latest for the perhaps the big ones that haven't committed to Markets Plus, Pacific or Nevada, whether they've jumped into the other one or not. Are there other big ones we haven't discussed? Maybe. So if you subject to check if they've jumped into Cal ISO, I would agree with that. If some of the big ones are still sitting tight, then I would perhaps disagree. But I don't know off the top of my head right now, Chair.
All right. Mr. Taylor asserts in his direct testimony that if Colorado wants to influence ongoing market design, then we may want to be at the table. Any thoughts on that as a cost of doing nothing?
It's an interesting stakeholder process, Supreme Court style. Where you get it to a person. No other thoughts, Chair.
All right. And just if public service company in the balancing area declined to enter any market, do you think it might be more difficult towards getting to that $230 million in annual savings to the extent that's possible?
It's possible. It also strikes me, Chair, that the primary impediments that are in front of us from getting that big 230 million or whatever it is benefits from full RTO integration more come down on the issues related to interconnection and transmission cost allocation authority. You know, we've had discussion indicating, you know, potential. I don't know. I'm not going to speculate, but you know, that seems to be a barrier that the company has indicated could jeopardize this, regardless of whether we make this step into Markets Plus now or do something else. So I at the beginning of this, I thought Markets Plus seemed like a step towards that, along with the characterization of your question. After the discussion over the last 2 days, I question that now. Right? I wonder if this is a step and a wait until things change on those other two issues. From the company's perspective, staff, I'm not prepared to give a position on that. I'm just observing the discussions.
All right. Let's talk a little bit more about the Markets Plus application. Ms. King suggested that this filing was maybe part of an undisclosed plan to build billions of dollars in new transmission to Arizona or the Pacific Northwest. But is it possible that this application could be viewed as part of a multi-year effort to implement the findings of the CTCA study and modeling? As such, you know, the goal of this multi-year effort is to get Colorado on a path to potentially realize those very large savings, whether it's $230 million or not. You know, even with the limited early production cost savings and the constrained footprint, given the seam between the Colorado balancing authorities, any thoughts about whether this application may be the best or maybe the only path toward realizing those larger savings?
I think it potentially comes down to, again, you know, does this step give us more helpful, I don't know if leverage is the right term, or opportunities to improve some of these other two big ticket issues, stopping, you know, full RTO integration, the interconnect challenges, and transmission authority. You know, if taking this step is helpful in those regards by perhaps giving the commission and the company a seat at the table with SPP to resolve those things in a helpful way, and then I think this could be a helpful step. I could see a scenario where holding out could also, but I don't know. I haven't thought through that fully enough to recommend that as a path, Chair. But I do, you know, as I've been listening the last few days, I'll repeat it again. I think that extra $230 million benefit, in my mind, more and more comes down to, can we get interconnection and transmission, you know, improved in a way such that the state and the company and all our other important partners are comfortable making that next step. And I don't know if we're there based on at least today, based on the conversations I've heard.
given that the WAPA BA seems likely to be an SPP, isn't the only path to, better integrating Colorado, which is where seemingly our strongest existing transmission is, through SPP?
That's possible, unless you could drag them out of SPP. But I think that's a fair instinct. But is it? Yeah, I think that's a fair instinct, Chair.
All right. And I get there's a long way to go and the path isn't clear, but is it possible that this level of potential annual savings, whether 200 million per year or whatever, is so much greater than the 20 or 30 million dollars in total net cumulative costs of Markets Plus? Said another way, isn't it possible that the Markets Plus net cost could be a reasonable investment towards realizing these potentially larger savings? Any thoughts on that?
200 million is 10 times greater than 20 million, Chair. And
200 million a year.
Fair enough.
And not all of it's
Compared to 20
Fiasco,
million
it's
total.
statewide.
Yeah, and it comes down to the costs, right? And I think we're talking now at this higher level, a bigger scale in both directions, right? If we can't get our generation built because of interconnection problems, the costs of jumping into that are going to jump in order of magnitude as well.
I'm asking you if we should jump into Markets Plus, where it doesn't seem like there's much downside between what appear to be relatively minor timing differences between the net costs and benefits, and then seeing if we can work out the other issues towards, realizing further integration. So, I get that the RTO West thing is maybe too big a step now. But the hypothesis that I'm trying to explore with you is, should we do Markets Plus as a useful step potentially along the way to those larger benefits, given that the only path forward appears maybe to be through SPP?
Yeah, I'm not sure that that's the only path. It's hard to say, but I think, to explore this hypothesis with you further, I think if this is the strategic move now, well, one you could do the calculus in front of you right now, which is, we think there's a small, I don't know, millions of dollars is maybe not small to a lot of folks, but it might be a net cost of $1 million from production costs and admin perspective. And is that worth the near-term benefits that we could get that weren't quantified? Greenhouse gas tracking, pricing data, and so on. I've used RTO pricing data in research and so on. There's a lot of benefit. There's benefit there, Chair, in terms of informational transparency. It'll give staff and other stakeholders a better source base of information upon which to ask questions about how the system is being run and operated and associated costs. So there's that near term. Are those non-quantified things worth, where we're at on the production costs of, net few $1 million a year? I would say to explore the longer term thing. I think we can't do it today, but it would be prudent and worthwhile somehow to start thinking through strategically what the steps are beyond just accepting this application, to give us a roadmap towards those bigger scale benefits and mitigating the bigger scale risks. So that's where my mind would go. If this is part of a step, then it would be worth strategically kind of trying to lay that out as best we can, and what pieces along the way after this initial decision can get us on this path that we want for big benefits for our state.
Well, that might be a good transition to the statement of position, but just a couple more questions. I don't know if you heard my conversation with Mr. Lester on resource adequacy. Any comments on whether this would be a significant improvement over the status quo, and my sort of back of the envelope conversation with Mr. Lester about quantifying, sort of surplus capacity cost.
The only question I had when listening to that, and this is not an assertion that this is true, but I had the question of, do the munis and co-ops and non-regulated entities you were discussing, are they committing to Western Resource Adequacy Program? I think they probably have an ability to decide or not whether they join this, this shared commitment to regional resource adequacy. And I just wasn't sure. I think the premise of those benefits assumes that these non-regulated entities also participate in the same regional construct you were talking about. And I just wasn't sure if they've made those commitments or if they're going to or not. So
I think it was somewhat ambiguous in Mr. Taylor's testimony, but I think he testified that if the load is in the balancing authority, the choice is to either leave the balancing authority or comply with those resource adequacy commitments. But I'll leave Mr. Taylor's testimony to stand for itself. Any thoughts on the GHG tracking and whether the PSGO tri-state letter addresses the concerns and improves the status quo? Thoughts on that?
I don't have any thoughts that are insightful enough to share with you right now, Chair.
Okay. Two last questions, maybe one. Is it fair to say that roughly 85% of the cost of this day-ahead market development are being paid for by utilities in Arizona and the Pacific Northwest?
Yeah, roughly.
Okay.
Given our current estimates of who's going to join, yeah.
I may not always agree with everything you say, Dr. Dalkey, but it's a pleasure having you back. So thank you. Thanks for the conversation. That's all I have. To staff council, would you have any objections, or would any other council have any objections if we took administrative notice of the CTC report that was submitted to the legislature? Mr. Kirkies?
Your Honor, I have not seen that report. I don't know how old it is. I have a couple redirect questions for Dr. Dalkey about it, since he was one of the authors of it. But if you are going to take administrative notice of it, I would just ask that it be added to the e-filings docket so that I can access it.
Oh, of course. Mr. Denman, any objections?
Your Honor, I'm familiar with the administrative notice rule, and if that's what you choose to do, I cannot object.
All right. Any advice? I mean, it seems like it's a PUC report to the legislature.
Certainly, Your Honor.
All right. Mr. Kirkies, redirect?
Yes, Your Honor, just briefly. And if we could please pull up Dr. Dalkey's answer testimony, it's hearing exhibit 500. And on page 28 is where I'm going to be directing my questions, at the top of page 28. Dr. Dalkey, do you remember an exchange with Mr. Denman about your testimony about FERC and whether that testimony was implying that Colorado should just defer to any federal policy or anything like that?
Yes, I recall that conversation.
Do you see on lines 1 through 6 of your testimony here where you state, if FERC were to limit or prohibit GHG pricing or tracking within SPP Markets Plus, it could undermine the market's ability to support state-mandated emissions reduction targets, potentially making continued participation less beneficial or even contrary to the public interest for states with emission reduction goals like Colorado. Did I read that correctly?
You did.
So to be clear, is it your testimony here that this market would be regulated by FERC and that if FERC prohibits or limits greenhouse gas tracking, that it would make it impossible for staff or other parties to verify that we're meeting our emissions goals. Would that be correct?
It would be impossible unless we implemented a new local procedure. It would be pretty disruptive.
And so would it be fair to say that you're not saying that Colorado should defer to the feds? What you're saying is the feds could frustrate Colorado's emissions policies here if they go down this path. Would that be correct?
Yes, they could.
And that would be if PSCO is allowed to join SPP Markets Plus, correct?
Yep.
Now, turning to, you had an exchange with the chairman about this report. I just want to be clear. Do you remember the date of that report?
No, I remember the year. I believe it was published in 2021.
Would it surprise you to learn it was June 2021?
Not too much.
Would you say the cost?
Can we just pull it up to the cover page?
December 2021, excuse me. Dr. Dalkey, would you say that the cost estimates from 2021 are consistent with what the current estimates of joining this the cost of joining this market or the savings from joining the market would be?
I think the orders of magnitudes remain similar between these two studies on the day ahead and real-time market scenarios. But there's certainly differences in the assumptions underlying these two studies. They were done years apart with different starting systems and different going forward assumptions. So it would be reasonable that there would also be some differences.
And just to be clear, this was not the study on which Public Service relied in its application, was it?
No.
Okay.
This was not the study used by Public Service in this application.
Okay. Now, there was a $230 million savings figure. Just to be clear, that was the potential savings for joining a full RTO, correct?
Correct.
And you listened to the prior witness testimony in this hearing, right?
I did.
Was it your impression that Public Service has committed to joining a full RTO by 2030, or was it your impression that there may be some delay in joining that market?
My impression was that I certainly wasn't hearing commitments, and I heard discussion about possibly delaying some of the full RTO if concerns the company raised aren't addressed by the statutory deadline.
Okay. Now, if we could go back to Dr. Dalkey's testimony, it's hearing exhibit 500. And this time I'd like to be at the bottom of page 6. Or excuse me, at the bottom of page 5. So here, Dr. Dalkey, you have a question and answer, and the question is, what criteria is the commission required to consider in determining whether Markets Plus participation is in the public interest? Have I read that correctly?
Yes.
And you state, commission rules specify that participation in a day-ahead market by a transmission investor-owned utility shall be determined to be in the public interest if the commission finds that the DAM the utility seeks to participate in. And then going down to the next page, starting on line 7, you have Roman numeral 3, has sufficient modeling and other analytical support showing that the expected benefits of joining that market, including the production cost decreases, reliability improvements, and emission reductions, are likely to exceed the expected costs. You have a footnote there. If we could scroll down, I believe the footnote is to Commission Rule 3753A. Is that correct? At the bottom of the page. And have I read that portion of your testimony correctly?
You did.
So is it your understanding, based on this portion of your testimony, and I know you're not a lawyer, but that the commission rules say that the costs and that the benefits of joining the specific market at issue, being the SPP Markets Plus in this case, must exceed the costs of joining that market in order for it to be approved? Would that be correct?
The rules specify that the applicant must have sufficient modeling and other analytical support such that the benefits are likely to exceed the expected costs.
So would it be your understanding that the commission rules allow the commission to approve joining SPP Markets Plus because they think that the benefits of eventually joining a full RTO will be sufficient, or do you think it has to be based on the benefits of SPP Markets Plus?
I think it has to be based on the benefits presented for the market under consideration, and not the any longer term goal or speculative possibility.
All right. Thank you, Dr. Dalkey. Mr. Chairman, I have no further questions.
Thank you, Dr. Dalkey. You may be excused.
Thank you.
Ms. Keene.
Thank you. If possible, would like to just request some clarity on the status of the Series 1500 exhibit. My first question, and apologies if this wasn't clear to me, but it's clear to others, regarding the sustained motion to strike, was the exhibit itself stricken, or was just the witness's testimony regarding that exhibit stricken?
My understanding is everything associated with that discussion, the exhibit and the witness testimony was stricken for improper foundation for multiple reasons.
Sure. Thank you. And then would the chair or commission counsel just please clarify for the parties which of the what new exhibits in the 1500 series are being entered into the record? And we'll obviously have that eventually, but with such a quick turnaround to SOPs, getting that clarity now would be greatly appreciated.
I guess my request would be to take administrative notice of the CTCA report. I forget the exhibit number. And then I think it'd be useful to make the other two exhibits available to the parties, but I think it's less critical for the record and it's probably less of a foundation. So I don't know, Ms. Rosati, thoughts about how to do this?
Yes, I believe that hearing exhibit 1505, the CTCA report, that you have taken administrative notice of that one. And then 150, what is it? 1504. 1504 is also in the commission's records. And so I would suggest taking administrative notice of 1504 and then formally moving hearing exhibit 1502, which was the CEO resource adequacy report, and seeing if parties have objections to that.
Any objections to that path forward on 1502 or 1504?
No, Your Honor.
Ms. Keene?
No, thank you. Just appreciate the clarity.
All right, so 1502 is moved into evidence. We're taking administrative notice of 1504 and 1505. Thanks, Ms. Rosati. And I think statements of position are due on June 2nd. June 12th. Sorry,
Yes.
June 12th. June 12th. Sorry.
Yes, Your Honor.
Mr. Fagno, Mr. Barossa?
I'll go first. Is Exhibit 902 in the record? Has it been admitted? That was the revision to MRG and attachment MRG 4 that AEU presented, and I never knew if it was admitted or just referred to and examined.
No, I think it was admitted. I think we admitted it this morning, Ms. Keen. Yes.
That's my recollection.
Yeah,
Thank you.
I agree, Your
Okay.
Honor. We dealt with that as a preliminary matter.
Okay. Thank you.
Mr. Barissa, did you have something?
I did not. Thank you, Chair.
All right. Anything else?
We think Your Honor has clarified the questions I had, and thanks, Ms. Keen, for bringing up the status of those 1500 series. We have nothing further, Your Honor.
Well, I just want to thank the parties for, and if, Mr. Crakes, did you have anything?
Oh, no, I was just turning on my camera to say thank you at the end of the hearing.
Oh, all right.
Thank you,
I just
Mr.
want to
Chairman.
thank everybody for an expeditious, efficient hearing. Just looking at the cross-examination matrix, I was worried we wouldn't get done by end of day Thursday. So delighted to have a day back, and just want to thank everybody for the thoughtful conversation and dialogue. As always, I learned a ton and appreciate it. So, Commissioner Gilman, final thoughts?
Yeah, no, same thank you to the parties, the witnesses, attorneys, as well as our internal advisors and counsel. And yeah, appreciate everyone wrapping it up. Thanks.
Commissioner Plant.
Yeah, I'd echo the thanks. Thanks to everybody for your thoughtful discussion, and I think you all learned a lot, so I appreciate it. And yeah, thanks for making it quick too.
With that, we're adjourned. Thanks
I would
all.
return a thank you, Mr. Chairman and Commissioners. Thank you very much for your attention in this case.
All right. Thanks all. With that, we're adjourned and the record is closed.
Thank you.
How do you